Okay, so that's 9 o'clock. I might start with a bit of an introduction whilst people are still joining us before we get to the meat of the topic. So for those of you who don't know, I'm Natalie Kearney. I'm a barrister at St Philip's Chambers, part of our business and property group, and a member of our business and property juniors committee. So some of you may have seen us at various pizza events, for example. Obviously lockdown's put a bit of a kibosh on that for now. But this is part of our long-running Breakfast Club 7 webinar series. Today's topic is going to be looking at part 19, so the addition and substitution of parties. And as part of that, I'll look at various scenarios. So I've got 3 questions that we'll run through. And we just had a spate of additional people joining us. So for those of you who missed that, I'm Natalie Kearney, and I'm going to be looking at addition and substitution of parties under part 19. So I hope you're all settled in, got your coffee. I'm going to load the PowerPoint now and we'll get going. There we are. So addition and substitution of parties, what am I going to be talking to you about? So 3 topics really, a quick overview of the provisions, so just rattling through what we can read in the CPR. And then 3 scenarios. So what do we do if the wrong party has been named by mistake? What if you want to join a party because you think they're going to assist in resolving the dispute between the parties? And what do you do if limitations expire by the time you realise that you want to take these steps? So a quick flash through our provisions. So part 19.2, where limitation hasn't ended, the court may order a new person to be added as a party if it's desirable to add that person so that the court can resolve the issues in dispute, or there's an issue between the new party that's proposed to be joined and an existing party, and it would be desirable for that to be resolved as part of the current proceedings. And in relation to substitution, the court may order that a new party be substituted for an existing party if the existing party's interest or liability has passed to that new party. For example, let's say there's been a merger or a buyout, and that it's desirable to substitute that new party so that the court can resolve the matters in dispute. So it's an and test. I also note here that this actually also provides for the court to remove parties where it's undesirable for them to continue to be party to those proceedings, but we're not going to look at that in any great detail this morning. So the procedure for making any application is 19.4. The key question here being, have you served the claim form? So if the claim form has been served, you're going to need the court's permission to remove, add or substitute a party. If you've not served it yet, you've just issued it, then you don't need the court's permission. Now, in relation to claimants in particular, rather than additional defendants, you can only substitute a claimant in if that claimant, the new claimant, has given their written consent and that consent's being filed with the court as part of the application. Because obviously the claimant's going to be on the hook for costs. Theoretically, down the line, they should really have consented to being part of that action. An order for the removal or addition of substitution of a party has to be served on all the parties to proceedings, including the person you're hoping to add. Common sense. They have to know that they're going to be part of proceedings. Otherwise, who do they know, who they're serving and who they're dealing with? And on making an order to add or substitute or remove, the court can then give directions as to how the matter is going to proceed, as you'd expect. So, for example, you add a second defendant, they're going to need a copy of the claim form if they haven't already had it. So it might be that the court then gives directions as to further service and gives directions as to whether defence should be filed by that second defendant. Now, the application is a normal Part 23 application and evidence is required. So there is a case, it's called Perciba here and Alvia Limited from 2016. It's the High Court case. And it's basically set out that a claimant seeking to add a second defendant, for example, has to have a good arguable case. And the question for the test that the court's going to look at really is the same as that for strikeout under 3.42. So are there reasonable grounds? It's not quite as high a hurdle as, say, you had a summary judgment application where it's a real prospect of success. It's reasonable grounds, it's an arguable case. So if we look then at our scenarios, so what if the wrong party has been named by mistake? Well, it very much depends on the type of mistake. Sorry for the barrister answer, but I'll become clearer why. For our purposes now, and we'll come on to outside limitation afterwards, let's presume we are within limitation. So limitation is not an issue, limitation is running, we're fine. If your mistake is a mistake as to the name of the party rather than changing the identity of the party, then your application is pursuant to part 17.3. For example, you wanted to sue Mr. Smith. Mr. Smith knew you wanted to sue Mr. Smith. You put Mr. Smith's address into the claim form for a service. You've served him at that address. In the pleadings, you've set out Mr. Smith's identity quite clearly. It was always supposed to be Mr. Smith, but when you've typed it into the system, you've put in Mr. Smith, Mr. H. Oops. Now, as I've put on the slide there, you would hope in such a scenario the other parties are going to consent to that amendment being made without you having to faff around making any formal applications. It might be that if all parties agree, the court will simply deal with that on the papers. In practice, quite often I'll have this crop up at a CMC, for example, case management conference, and I'll just have a chat with the other side and say, you know, can we just tell the judge that we just need to amend the name slightly? And in most cases, that's very sensibly dealt with. You might, for example, I've had this happen a few times, you have a litigant in person who's commenced proceedings against a company and they've mislimited off the end. And everybody knows who's dealing with it. You get to they've then subsequently ceased being a litigant in person. They've instructed a solicitor to act on their behalf. You get to your case management conference and you say, well, we're here, they're also here, they know it's the limited company. Will you just let us put limited on the claim form? And in most cases that's dealt with as you would expect, and that would be under part 17.3. Now the trickier part is where you've named the wrong defendant and it's not quite as straightforward as missing out a letter or missing off limited. So for example, you've named a limited company on your claim form, but your contract was with their subsidiary. It's a different limited company. And so in reality, if you add or substitute the party, you're going to have to serve a new party. So it's not quite the same as our scenario where you've mistyped and served the same person. But your pleadings will, in this scenario, we're saying the pleadings that you've prepared identify the details of this party, save for the name is wrong. So then we're looking at part 19 rather than part 17. And so if we focus first of all on substitution, because that's what's happening here, you are substituting the correct named company for the incorrectly named company. So the court's going to look at the points I've set out in 19.24. Has the existing party's interest or liability passed to the new party? And is it desirable to substitute the new party so the court can resolve the matters in dispute? If the answer to both of those questions is yes, then the court may, and it is discretionary, so the court doesn't have to let that happen just because you meet those two criteria, but it may. And I'll note there that in our scenario, it doesn't really sit well with the first part, the existing party's interest or liability is passed to the new party. Well, it hasn't passed because they always had it. But the court actually has a broader discretion, despite 19.24 giving us those two sub-clauses in essence, that the interest is passed and it's desirable. In reality, the court's, it's a broader discretion. It's where it's desirable the court may make an order to substitute. And so if it's desirable for that substitution to take place, the court is likely to make that substitution. So in our scenario, in relation to those two companies, the subsidiary company and the parent company, provided that the pleadings are quite clear, it's always supposed to be that company who was named, and it was just a mistake, you would hope that it's more likely than not the court would let you substitute under 19.24. Now, in relation to addition within limitation, we've got this new scenario. So what if you want to join a party to assist in resolving the dispute? Now, the term in dispute, before we get onto this example, should be read as being matters in issue. And that comes from the Pablo Star Limited case of 2017. And one factor to be aware, if you are seeking to join parties, is how complex your litigation is already and how many people are already parties to those proceedings, because the court isn't going to be particularly enamoured with the idea of having lots and lots of defendants being added, or lots and lots of claimants being added, and overcomplicating matters where it isn't necessary. So if we look first of all at the second element, so adding a party to resolve connected issues. So in our scenario here, we have a claimant pursuing 3 different defendants, and those defendants are all insured. So if you're looking at this board in front of you, you've got defendant 1 is insured by insurer A, defendant 2 insurer B, defendant 3 is a dormant company, and I'm telling you that they're insured by insurer C. So for our purposes, that is the scenario. And the claimant is pursuing all 3 defendants. Insurer A and Insurer B have been added by D1 and D2. And actually, the defendants and the insurers are quite keen to settle this case. But they want to know, well, how much are we on the hook for? We know Insurer C at some point is going to have to pay out for defendant company 3, but they aren't a party to these proceedings. So we don't really know what's going on because they aren't actively taking part. So we want to add them to the proceedings to help us settle it, in essence, because then they have to get involved. And so some of you might be thinking, oh, I've got a raised hand. If I pause just there a moment then. If it's a question, I can't see a question or anything in that regard. If you do have questions during, I should have said this at the start actually, if you want to use the Q&A, pop your questions in, and at the end I will pop into the Q&As, and if there's something I can answer there and then I will. If there isn't, or it's something that might require a better answer or a longer answer than we have time for, I'm happy to come back to people on email afterwards. So I can't see a question there popping up, so I'll come back to that at the end if I may. So we're talking about this scenario in front of us. So we've got insurers wanting to settle. They want to add the insurer C. Will the court let them add this insurer on the basis of, well, it will help us settle, help us resolve it by settling? Well, these are the facts of a personal injury matter in reality. It's the PIP breast implant litigation from 2014. The claimant was pursuing the defendants, the insurers wanted to add in another insurer, as I say. And in those circumstances, the court refused to add insurer C because they said, well, really, the matter can be resolved without adding insurer C. The issues between the parties can be resolved as they are. The claimant is pursuing the defendant's liability can be settled as is. And the position in relation to the insurer, who isn't a party, doesn't affect liability, and therefore it's not necessary to add. So in essence, the question for the court is going to be, are you seeking to add this party to proceedings to resolve the issues in dispute? So it's resolving the issues, not to just improve the prospects of settling the matter, which might be frustrating, but that is unfortunately the test. So if the claimant has reasonable grounds for seeking to add a new defendant, i.e. new defendant has caused the claimant some loss, then it's likely to be desirable. The court are likely to add that party. And if you're on the receiving end of a joinder application in that regard, and again, this part 20 obviously to look at as well, it's rarely going to be appropriate for a potential defendant to resist joinder on a collateral issue. And so I've mentioned there the case of Lifestyles Equities. Now in that case, a potential defendant sought to resist an application to be made a party on the basis that the claim was likely to be stayed, on a technical ground that we don't need to go into, but the claim was likely to be stayed, and they said, well, don't add us at this point because the claim is going to be stayed. And the court refused to deny the joinder, because in essence what would have happened is that if the claim was stayed, the defendant was potentially, or the proposed defendant, would obtain a limitation defence, an advantage that it wouldn't have had otherwise. And so again, if you're on the receiving end of what seems to be a sensible joinder, if you have a technical point, it's unlikely to get you home because of this, what is seen to be an unfair advantage you may be getting in relation to limitation, although each case obviously should be assessed on its own facts. And at the bottom there we have the Milton Keynes case that I've put in Viridor from 2016. It's a TCC case from the High Court. And in that case, what was being sought was rectification of a contract. Now, the defendant in that case had been bought out, all of its shares had been purchased by the proposed second defendant. And the purpose of the joinder was the defendant, so Viridor in this case, was trying to add the second defendant to give them additional defence. So the new owner was a third party who had acquired an interest in Viridor without notice of any entitlement that the claimant might seek to rectify the contract. So in essence, an equitable claim. We're looking at bona fide purchaser without notice. And the court in that case said, well, no, we're not adding the second defendant on those grounds to give you an additional defence, primarily on the basis that the reasons in which that joinder can take place are in 19.2.2. And adding the second defendant isn't desirable to resolve the issues in dispute between these parties, or a dispute between Viridor and the proposed second defendant, or the claimant and the proposed second defendant, because the claim is for rectification of the contract. And adding in the second defendant won't affect whether the contract should be rectified or not, because we're looking at what was intended at the time the contract was entered into. So that's where we are on joinder. So if there are reasonable grounds, then most likely you're going to get home on an application to join a party, provided that it is desirable to resolve the issues in dispute between the parties, either the existing parties or an existing party and that proposed new party. Which is all great. So now you think, we're in limitation, you've looked at your papers, you think you've got a mistake, and then you realise, limitation's expired. Well, how does that change what we're looking at? Well, Section 35 of the Limitation Act 1980 sets out the provisions, but these are carried through into Part 17 and 19 of the CPR. So if we take our previous scenario, so we're in Part 17, you've got a mistaken name of a defendant. So we're no longer in 17.3, we're in 17.4 where limitations expired. And so the court will allow an amendment to correct a mistake as to the name, but only where the mistake was genuine and not one which would cause reasonable doubt as to the identity of the party in question. Now, I'll clarify here, mistake doesn't mean that it has to be an error without fault. So there can be fault involved, and that comes from the case of Mitchell and Harris Engineering from 1967. An example of when this might take place would be that the action is brought in the name of a company that ceased to exist as a result of a merger, as we discussed before. The court can correct the name since the mistake is one of nomenclature rather than the actual identity. So as we discussed before, it's simply a matter, Smith and Smith, everyone knew who we were talking about. It was a genuine mistake. We always intended to pursue Mr. Smith. There's no reasonable doubt as to the identity of the party because Mr. Smith knew we meant him. We've pleaded it was him, we served him. And so the court's likely in that scenario in 17.4 to permit the amendment to correct the name. And it will also allow amendment to alter the capacity in which a party claims if the new capacity is one which the party had when the proceedings started or has since acquired. As we discussed before, this is possibly with administrators coming into a company. Or you might perhaps have an executor of an estate if a person has sadly died in the course of proceedings. Now, as before, this is the more straightforward of the two. We have a claimant and a defendant who we know who they are. The mistake is only in relation to how they've been identified in nomenclature and not their actual identity. But as before, if we have something a bit more complicated than that, where we think, well, we are actually changing the party, you're in Part 19, and Part 19.5 specifically is relevant where we have additional substitution outside of limitation. And so this is slightly more strict, as you would expect. The court may add or substitute a party only if the relevant limitation period was current when the proceedings were started. So common sense, if you miss limitation, you can't use this as a backdoor to get in. And the addition or substitution is necessary. Well, what's necessary? Well, there are three elements set out. The first being that the new party is being substituted for a party who was named in the claim form in mistake for the new party. Again, you've named the subsidiary rather than the parent or vice versa. The claim cannot properly be carried on by or against the original party unless the new party is added or substituted, and we'll come on to an example of that because that can get quite complicated. Or that the original parties died or had a bankruptcy order made against them and their interests or liabilities passed. I'll put the caveat at the bottom there, though I won't focus on it. Personal injuries have an additional exception where the court can extend limitation, as some of you may be aware, and the court can decide to deal with that as part of the Part 19.5 application, or can push that issue off to trial, but we're not going to go into any detail on that. So 19.53, it should be used where the name of the, rather than 17.4, where the name of the party doesn't match the identity of the party set out in the statements of case. For example, as we've said before, if the amendment is allowed, you're going to have to serve a different party. Looking at the second limb then, what do we mean when we say that a claim can't be carried out against the original party unless the new party is added or substituted? I'm going to go through some examples of cases, but the first one I've got there is Natalie and Sabre Insurance from 2013, and it is a Court of Appeal case. And although it's a personal injury claim, I think it's perhaps helpful. A lot of these are personal injury claims, perhaps because the nature of who the parties are perhaps is more flexible than they would be in contract claims. Because hopefully, although we know it's not always the case, we'd have a written contract. But this is a personal injury claim. And the claim arose out of an accident overseas. So the claimant was a passenger in a vehicle. There was an accident, and sadly the driver of that vehicle was killed. And it was insured by Sabre Insurance. And the claimant sought to pursue a claim against the insurance company under what are known as the European Community's Rights Against Insurers Regulations 2002. So it's a cause of action under EU regulations. That means you don't have to add the defendants or the insured to those proceedings under the regulations for the matter to proceed, which is great if the regulations actually apply. And as it turns out in this case, the regulations didn't apply to the proceedings, but the claimant was out of time. And so the claim against the insurer was doomed to fail unless somehow they could get the deceased estate in. So they sought to use 19.53b to join in the deceased estate to proceedings. Well, the Court of Appeal refused, because although they said, you know, it all arises from the same accident, what you're pursuing is damages in relation to an accident, your cause of action isn't the same. The cause of action pleaded was under the regulations against the insurer. A cause of action against the deceased estate would be a tortious claim, a duty of care negligence claim. It's a new cause of action. So it's not that the original claim can't proceed without adding them, it's that you're seeking to add a new party and a new cause of action. And so that's something to be aware of, is that if you're seeking to add or substitute a new party outside of limitation, is the claim as pleaded in such a way that it would catch your proposed new defendant? Because if it's a new cause of action that's required, it's not going to succeed under 19.53b, because it's not necessary for the original action or original cause of action to proceed. So that's one thing to be aware of when looking at these applications. Now, two other examples, slightly less complicated examples. We have Parkinson Engineering Services and Swan. It's another Court of Appeal case from 2009. And in that case, a liquidator of a company was added as a claimant in substitution for the company itself. And that was in circumstances where the defendant had a complete defence to the claim by the company. But that could be overcome if the same claim was then brought by the liquidator instead. So the court was willing to permit a substitution of a claimant to let that claim proceed outside of limitation. And there we have Irwin and Lynch, another Court of Appeal case from 2010. Again, it's an insolvency case. A company was added as a claimant to proceedings in substitution for its administrator, because the claim had been brought by the administrator, but the administrator in fact didn't have standing to bring that claim. But the company did have standing, and so the court was satisfied that it could substitute in those circumstances so the claim could proceed. Again, the cause of action was the same, just that the party needed to be substituted for that cause of action to continue. And so, in summary, what we need to be looking at, first of all, is, has your claim form been served? If it hasn't, then great, you don't need the court's permission to amend. This is again proceeding with limitation. Secondly, limitation. Are you within the limitation period? Are you outside the limitation period? Because that's going to affect the test you're trying to meet and the threshold that you're trying to satisfy. If we're within limitation, then we're looking at part 17.3 for mistakes of nomenclature. So your Mr. Smith scenario where we've missed a letter off, or where you've got a company you've missed off the limited. If it's actually going to mean something slightly more, so you're going to have to serve a new party because in essence it's substitution, then you're not in part 17, you're in part 19. And then you're looking at whether, for substitution, whether it's desirable. So the court can resolve the issues in dispute. The key bit there, it's desirable. Or if you're looking to add a party, the key question again is desirability. And it's not just desirability to help the matter settle, it's desirability to resolve the issues in dispute, either between the existing parties or an existing party and a new party. And if we're outside of limitation, as we've just gone through, you're looking at 17.4 and 19.5. If we're in 17.4, our simple scenario of Mr. Smith being Mr. Smith, then the question is it a genuine mistake? So you always intended to name Mr. Smith. You never intended to name Mr. Smith. And the second part is that there's no reasonable doubt could have been caused by you doing it. Again, using the Mr. Smith example, he was clearly intended to be the party. You served him. Nobody could doubt that you intended to serve him and pursue him. With 19.5, we're back into this only. It's this restriction. Its limitation cannot have expired at the time the original proceedings were brought. Common sense, again, you would think, because it can't be a backdoor around limitation. But that it has to be necessary. Is the additional substitution necessary? And then there are those three elements we went through. So is it a mistake? Can the action be carried on without adding or substituting the party? And has the interest and liability passed to this new party? And it's not a backdoor for a new cause of action. And that's all I have to say on part 17 and part 19. So I will stop sharing my screen now and have a look to see if we've got any questions in the Q&As or if there's anything in the chat. So bear with me just a moment. No questions this morning? Well, I'll hang on for a couple of moments now in case anyone thinks of anything they desperately want to ask me. Otherwise, I'm happy to take email inquiries and my details are up on the St Philip's website. It's been a pleasure talking to you all, even if I can't see you. I hope the weather's better where you are than it is with me.